Thank you so much for tuning in. This is attorney Matt Wayman here today to talk to you about motions to suppress evidence. Motions to suppress are based on a person's Fourth Amendment right against unreasonable searches and seizures. When we talk about motions to suppress, we generally talk about three areas: motions to suppress evidence, identification, and statements. This video is going to specifically focus on motions to suppress evidence. Motions to suppress evidence are filed by the criminal defense attorney. Once these motions are filed, the burden then shifts to the state to prove that that evidence was obtained lawfully and without coercion. A hearing will generally be held on the motion. It's kind of like a mini trial. The state will call witnesses to demonstrate why the motion should be overruled because the evidence was obtained lawfully, and the defense will have a chance to cross-examine those witnesses and poke holes in their story and ask the judge to grant their motion to suppress. A lot of times we're asking to suppress evidence that was obtained as a result of the search of a vehicle or the search of a residence. There are many different types of searches of vehicles. The first one would be a consent search. This is where the driver of the vehicle gives consent to a police officer to search that vehicle. So the officer comes up to the car and says, "May I search?" And the person says yes. It is much harder to suppress evidence obtained as a result of a consent search because that person gave their consent to search that vehicle. The next type of search would be a probable cause search. This is where the officer is able to articulate facts that rise to the level of probable cause that allows them to search that vehicle. An example would be an officer pulls over a rental vehicle where the driver does not have the rental agreement or is not authorized to drive that rental car, and the car smells like marijuana, and there's a bunch of upholstery tools in that vehicle, and the driver of that vehicle is super nervous and doesn't want to give that officer his ID. That would likely be held to be probable cause to search that vehicle. Another way that officers develop probable cause is that they'll bring a drug dog out to walk around that car, and if that drug dog hits on something inside that vehicle, then that would give them probable cause to search that vehicle. The next type of search that we're going to be talking about is a search incident to arrest. Say an officer walks up to a car and sees a pipe and marijuana sitting on the seat. They have probable cause that a crime has been committed, so then at that point they can arrest that person, and then after they arrest that person, they're allowed to perform an inventory search of that vehicle prior to that vehicle being towed away by a tow company. The last type of search we're going to be talking about is a warrant search. This is where the officers have a valid warrant to search that specific vehicle and are allowed to go through that vehicle to see if they can obtain the evidence that is spelled out in that warrant that they think is in that vehicle. There are many different avenues to challenge the search of vehicles, the most common being that the officers did not have probable cause to search that vehicle. It's based off a totality of the circumstances, so you would spell out all the factors that the officers relied on and then argue that all those factors taken in their totality did not rise to the level of giving the officers probable cause to search that vehicle. The next thing we're going to chat about is the search of residences. Common grounds to challenge the search of residences would be that the officers didn't rely on a valid warrant, that the warrant was issued without probable cause, or that the search performed by the officers exceeded the scope of the warrant. An example of that would be if the officers had a warrant to search for a long assault rifle and they searched a small drawer and found drugs inside that small drawer. There's no chance that that long assault rifle could fit inside that small drawer, so the search exceeded the scope of the warrant because the warrant was specifically to find that long assault rifle. After a hearing is held on the motion to suppress either the search of a residence or the search of a vehicle, a judge will issue an order either granting the defendant's motion or overruling their motion and allowing the evidence to be admissible. This order is interlocutory, which means that it is temporary and can change if the facts surrounding the case change. In practice, the granting of a motion to suppress will often lead to the charges against that person being dismissed. I hope this video has been helpful to give you a brief introduction on motions to suppress evidence. If you got any more questions, please feel free to comment down below or reach out to us directly. I want to thank you all so much for tuning in. We're going to be back soon with more videos.